Alrighty.
We have launched.
Welcome, everybody. Planet Green Trees, episode 164. We're calling it Edibles and Extractions. Today's officially September 5th, 2013. Call number is 1-347-326-9626. And you, of course, are listening to Planet Green Trees, Michigan's premier blog talk, medical cannabis and cannabis reform radio show. I'm your host, Michael Komorn, in the studio with me to bring you the best entertainment, pertinent, relevant, and pressing information. Chad from the Birmingham Compassion Club.
Good evening. It's nice to be here.
World-renowned producer and from Third Coast Compassion Center, Jamie Lowell. Welcome.
Hello.
And, of course, the man that's bringing the news and a lot more, editor-in-chief of the Compassion Chronicles, Rick Thompson.
I'm here.
All right. We've, as always, got nothing but excitement and interesting topics and special guests. And tonight we're going to continue the discussion of a very important case, People versus Earl Carruthers, which case, of course, concerns the Court of Appeals ruling removing the protections of Section 4, protecting an individual from arrest and prosecution when using marijuana extracts, as well as the apparent policy shift on federal priorities concerning marijuana. We are going to be talking about those things. Additionally, we are going to be talking about having as a guest Montana Attorney Chris Lindsey, who's a legislative analyst for the Marijuana Policy Project and Michigan's MPP liaison. Chris will discuss his background in marijuana reform and what has gone on in Montana, as well as his thoughts on the Carruthers decision and the overall view of concentrates and the implications of the recent Department of Justice policy shift on marijuana cases in states that have made it legal for medical and recreational use. Also, mother of a medical marijuana patient under the age of 18, Rebecca Hamilton Brown, will join us. She has seen the negative effects of the Court of Appeals decision, People versus Carruthers, making marijuana concentrates illegal. Rebecca is aware of parents and other young patients struggling to provide adequate treatment and the problems caused by the ruling for the medical marijuana community at large. And our very good friend, Robin Schneider, the legislative chairwoman for the National Patients' Rights Association, NPRA, will weigh in on the concentrate issue and let us know of any legislative efforts to help resolve the problems it has caused. She will also update us on the Provisioning Center bill, House Bill 4271, and promote the upcoming NPRA fundraiser to help support these legislative actions, which is going to be taking place in Ann Arbor on September 14th at the Ann Arbor Arts Center, 6 p.m. Our trustee core report from Steve Green of the Michigan chapter of the Human Solutions. You want to check out episode 163, where our bad technology but good guest by the name of Jamie, the National Director of the Human Solution,
Joe Grumbine,
from last week, is recorded on 163.
Mr. Grumbine.
Please listen. Interesting stuff. Anyways, of course, tonight's show contributed by all the participants here: Rick Thompson from the Compassion Chronicles, Jamie Lowell, Chad from Birmingham Compassion. Tonight's show is being sponsored by Komorn Law, 1-800-656-3557, the Michigan Medical Marijuana Association, MichiganMedicalMarijuana.org. Thanks to all the moderators and administrators helping to make that forums in the environment safe and comfortable for people to evolve the conversation. I want to also give a shout out to Kevin Spitler, Ostemo, Michigan. Also the Marijuana Rancher Cultural Center in Detroit. Call for your tours. Discounts on weekends, 313-422-5281. And our good friend Dr. Kumar Singh at the Greenlight Clinic, who is participating in the gold standard and willing to come to court and defend his certification. So those are some things we got going on. A lot to talk about. I'm excited we're going to have some lawyers on the show tonight. I always like talking to lawyers and hearing their take on things, especially in light of all the announcements of the federal government. I think no matter where you go and what you think is going to happen, I think until the X factor, the federal government has played its hand, we don't really know, nor can we predict how things are going to play out. So keeping an eye on the national perspective is very, very important. And, of course, Montana was one of the states immediately before Michigan, and I think much of the Michigan law was framed on the principles outlined in the Montana initiative.
They had a lot more legislative interference, though.
They had a lot more legislative interference, but the votes that were taken, the way that it was, the opponents may have said, exploited, caused a lot of legislative reactionary activities, which seemingly reduced and eliminated some of the protections that existed before. I remember we had...
the feds hit them very hard in a concentrated manner right in one of their big cities, right?
We had the shark attack guy, and he was talking about how the number of patients went from like 30,000 to 5,000. The number of caregivers in the triple digits from thousands, right? I mean, that was the impact of what had happened. People just become fearful. All right, but I'm going to rant a little bit right now. I don't want to get too off topic here. But in looking at where we are right now, I'd like to give a little anecdotal story of some things that happened, and had some encounters today where I met with some prosecutors and police officers to discuss some forfeiture matters. And it never ceases to amaze me, just the lack of common sense that's being used in the game that's being played. A lot of times when you're playing lawyer, being a lawyer, you're in a certain role that you're representing a certain side, and each of the participants is going to fulfill their obligations as well as they can. I mean, sometimes the discussion, debate is about, how strong they can stand in their convictions and in their employment and whatnot. And sometimes, they can't defend it. But had some interesting discussions today about the forfeiture laws with some prosecutors that want to keep money that was taken from a house that was earned lawfully. And really the questions about, what is the issue? What is the issue? Why are we even talking? Why are we having this meeting? And why is there money that's at issue? And what is the problem? And it still is an environment where prosecutors love to find and point out the violations of Section 4. They're hanging their hat on that. Because if they can find that, they can argue that they can keep the money, the behavior is legal, it's arrestable, it's not protected by Section 4, you're not immune. But they always forget the significance of Section 8 and the value of Section 8. And we're having this conversation where, we're in a position where we either have to post a bond to place our interest in the client's property so we can fight about it, or if we don't, then they're just going to keep it, and it's worthwhile property that they'd had from means other than anything related to medical marijuana. And the police, of course, want to keep all of this, and they want to find the flaw. And any flaw that they find in the protections of Section 4 allow them to take things and try to keep them. And then we're negotiating about it. You want us to pay how much money to get back the items that my clients have owned for 30 years? And why? Because you say their door wasn't open or wasn't closed? It's really silly. I mean, it's not in the same view of, what maybe this was intended for, which was that, some of you may have seen an MTV video back in the 80s or 90s with, gold chains and, people and making money and all of that goes along with the traditional, cartel type of viewed drug trafficking that none of these situations really are. But as we talk about these things and we're discussing the money, the questions come up, what should my clients have done? If they're earning money from being caregivers and provided to their connected patients and they happen to gross net $400 a week, where are they supposed to put it? They can't call the state and say, here's my nonprofit business or my for-profit business of caregiving so I can write off my expenses and, cross-reference my earnings and I can report tax. And that doesn't exist. So where are they going to put it? When you see money, law enforcement community, why is it automatically dirty when there are lawful endeavors that can take place within the Medical Marijuana Act and people we know now can sell marijuana? And selling marijuana is not the crime. It is not the crucial issue. People who live in a capitalist society, democracy, who vote, they're going to expect that people are going to earn money. Question is, what are you going to do with it? Is it being received and not be able to put in the bank for the sole purpose that when the police come in, it's sitting there and they can take it? Give me another place that should have been. Give me an idea where those items, that property should be. And there isn't an answer. It's a circular dance, dog chasing its tail around a tree. It is laughable because it keeps coming back to, well, you can't sell to your sick patient, and it's arrestable. I'm like, okay, but that patient is sick and they've got cancer. And if you think the entire case is going to be about and only about the sick patient transfer when the patient's asymmetrically protected but the caregiver isn't, and if you think those are going to be the issues that are going to be considered by the jury, you think they're going to ignore the sick patient because something about the card and a sick pay 5 and connected to, you think that's going to matter to them? They have to take 4 days off of work, and when they begin to deliberate in the jury room, they turn to each other and say, I thought we had a medical marijuana law. Didn't we pass something? Why am I sitting here? Because at the end of the day, the logic here, the arguments as we're negotiating and talking about whether we want to move forward with this or not, it's a game. It's a game. And, if you've got no defenses and it's not something that, if your only defenses are, pre-medical marijuana where it wasn't me or the police are lying and, you're going to ride that out in a defense of property or money that's been taken, it's a different story. But, and that's the position that they come at. That's the position why they can say to you, well, counsel, the way I'm looking at it, your client can give us X amount of dollars and we'll give him his car back. Why? Why does he have to give you money to get his car back? Because you took it and you're wrong, but because you took it, we have to either give you money to get it back or post a bond to secure interest in it. There's a lot of interesting things that come up at the front end of these encounters with law enforcement, many of which people probably do not think about, but I mentioned so that they will. And keeping cash sums around when the police are in your house is not something that I advise.
They always take it every single time, no matter how little it is.
Without question.
I've seen them take $37.
The worst is the two incidences recently where jewelry was taken and not accounted for in the search warrant return. Mm-hmm. One of which, when we brought it to the attention of the officer in charge, they immediately, sorry. Oh, we forgot. Let me get that for you. We'll get that right to you. And the next one is yet to be realized yet, Lord. But it will be. Nonetheless, it is a very almost bizarre conversation that takes place here when you're discussing these issues of forfeiture that most people aren't thinking about. And when they hear about how the law works, they say, that's the law in our country? They can do that? And it is brutal. And
forfeiture reform is a major, major thing still for patients and caregivers that we need to be involved in.
The prosecutor, she wouldn't acknowledge it probably publicly, but she, in our conversation, there can be no growth of the medical marijuana community if the forfeiture laws remain. And she acknowledged that. But here's the thing that I kept coming back with, which I want everybody to understand. It's not the preferred way. I don't think that anyone should have to go through this. I don't want to be misunderstood as saying that this is a good thing, but in response to any kind of commentary of the money being dirty or not from lawful means or the property being acquired from marijuana, whatever it may be, what I kept responding to her was, if we win our Section 8 motion, we get everything back. You know that if we establish those for medical purposes, there is no forfeiture, in the order dismissing pursuant to the Michigan Medical Marijuana Act, Section 8 specifically allows will direct the judge in the forfeiture case to return the property. And I'll get an order to that effect, and I'll argue that. So don't tell me we got to take it or leave it, because
it's in Section 8.
It's in Section 8, and when we win Section 8, I'm coming to get it back, and you're going to get nothing. So you better reconsider whether or not you're going to give us the cars back now, or are they going to give us the money back? Because there are protections here that are intended to apply. They all should be in Section 4, and people shouldn't have to go through this, but there's a lot of fight in this act, and I still think much that hasn't even been explored yet. I think more people have defendable cases than they realize, It's a shame that they get arrested, but there's much of this law that allows for an explanation of how individuals use cannabis medically. And I guess in a way, my talking points early on were that it's not a bad law. It's not a poorly written law. It's very clear. Depends where your mindset is. If you're looking for a law that's going to be restrictive of what people can do, it's not in that act because they cannot be articulated. You cannot specify in an initiative, and even the law that comes after it, the specifics that would have been necessary to apply to all who may be medical marijuana patients, to allow the liberality of people to use cannabis medically, because there's a number of different ways, as we've come to learn, of how it affects people and different methods of ingestion. But
even the Court of Appeals acknowledged that people must be able to use oral forms of cannabis.
You're talking about Carruthers?
In Carruthers.
But the point is that this law, and I think the writers of the MPP will agree, we can ask our guest tonight, Chris Lindsey, about whether this is true or not, but I believe it was intended and written in a very broad fashion. It was intended to apply to a number of different persons, intended to be looked at, it's a law that's written with the intent of preventing arrest and protecting the individual. It's not one that creates a law that says if you violate this is what the penalties are, like many of the other laws. This is one that says what you're protected from if you're doing this and what happens if you're not. And that's how the courts have interpreted it. So, my view has always been that the law needed to be interpreted broadly. It was intended for such. Why? Because you can't predict all the different methods by which people are going to need the medical uses of cannabis. And the Act itself allowed for, in a plain reading of it, many, many different interpretations that justify a number of different types of activity. Now that it's been rammed through the court system, its limitations have been realized and forced back into the patient community, in some instances even making it unworkable. We'll talk about that more later. But at the end of the day, that view of the law being interpreted in a way that would be broad, I think ends up being in your Section 8 defense. That the ability to explain, specifically to you, without any, absolute direction and limitations on what you can say and what you can't do in Section 8, is where the broadness of the Act is realized. It's in the ability of the patient or the caregiver to explain without limitation. There is no, you can't say medical marijuana. You can't. It is about medical use. And when I talk to patients who are going to testify at a Section 8 hearing, I remind them that as if they were a writer, an author, or a director of a movie on a TV show. They're going to get on the stand. They're going to look out at the audience. They're going to see cameras and people looking at them. They're going to potentially freak out. But the questions that are going to be asked of them are going to be about themselves, about their experience as a patient, about how they use cannabis medically. And the questions that are going to be asked by me or by the prosecutor can only be answered truthfully because the patient is the only one that really knows them. There's no other answer. It's like the author or the director of the movie who is on Letterman, for example. Well, in the last 30 minutes, this thing happened in the movie. Doesn't it mean that? Isn't that what really you're saying in your movie? No, it's not. I'm the director. I wrote the movie. It's my story. This is what it is. Nobody can alter you from that. It's your story of how you use medical cannabis. It's your story as a caregiver, how it is used, how there may have been, a research and development period where you're working with the patients, trying to get the exact dosing and strain and method of ingestion. There's a lot there. There's a lot of activities, and patients who are getting the benefits of good caregiving and various methods of cannabis to treat their conditions should be and would be, and have no reason not to come to court and make the case for you, whether they're one of your 5 patients, your 7th patient, your 50th patient. The fact is that the way the law has been handed to us at this point, the way the courts have ruled, people are going to get arrested And it is unfortunate. It's been a failure of the Act that the protections don't exist in Section 4. But the good news is that there are a lot of ways to defend in these cases. And as I advise all the people that come to my office or call me and ask me for what they should and should not do, my advice is to be ready to defend yourself in a Section 8 defense. You know, you can't call from the jail cell and say, get all the paperwork together. You know, it's not going to happen. You got to be thinking about things now. You got to make sure your patients are having bona fide relationships with their doctors. Make sure everyone's card's in order. Make sure your plant count is right. Take a couple steps back even from that. And try to become a perpetual grower. You know, the idea of harvesting all your plants at the same time is a lot of liability at this stage. And if you're going to be a master grower, caregiver that specializes in providing good quality cannabis, you know, step it up a notch. Try to see if you can work one plant every couple of weeks or two plants every couple of weeks, and then, you know, rotate them around from, you know what I'm talking about. All right, so that's the rant for right now. We can talk more about this and just the direction of where the Act's going and some of the unworkable things that have come from the Court of Appeals as of late. But we're going to take a quick break and come back with our internationally renowned guests and a lot more entertainment.